as far as Eagletech goes, do you all have any revenues and profits?
Our company was attacked at the point where we had just gotten our patents and we were bringing our product to market, and the market cap of the company at that point, $130 million, was reduced to near nothing by a group of criminal stock manipulators before the company's product had an opportunity to take foothold in the marketplace.
All right, thank
you. Your time is up. I have a question as well, but I'll wait till you come back for your rebuttal. Thank you.
All right, thank you.
We'll next hear from the counsel for the division. Mr. Byrne, you may proceed.
Good morning, Commissioner Glassman, members of the Commission. My name is Anthony Byrne. I'm an attorney with the Northeast Regional Office, and I represent the Division of Enforcement in the matter before you. The issue in this case is whether deregistration is the appropriate sanction where the respondent issuer has not filed its periodic reports for more than 3 years and offers no assurances that it can or will become current in its reporting requirements in the foreseeable future. I will address some of Eagletech's allegations in response, but first let me address the matters in this proceeding. First and foremost, the facts are undisputed. Eagletech's common stock has been registered with the Commission since 2000. Since then, Eagletech has been aware of its reporting obligations and had in fact filed several periodic reports since filing its registration statement. However, as Eagletech conceded at the pre-hearing telephone conference, it had not filed a periodic report since February 19, 2002, when it filed its third quarter Form 10Q for its third quarter of its fiscal year 2001. More importantly, however, Eagletech has not filed an annual report containing audited financial statements since August 14, 2001. Based on these uncontested facts, Law Judge Kelly properly concluded that Eagletech has violated and continues to violate Section 13A of the Exchange Act and Rules 13A-1 and 13A-13 pursuant to that act. Based on these violations, before you this morning is the issue whether Eagletech's deregistration is the appropriate sanction, where Eagletech has not complied with the law and offers no assurances that it will comply. Section 12J of the Exchange Act authorizes the Commission to revoke the registration of a security or suspend the registration of a security for a period not exceeding 12 months if it finds, after notice and an opportunity to be heard, that the issuer of such security has failed to comply with any provision of the Exchange Act or the rules thereunder. The provisions at issue here are the reporting provisions under Section 13. The purpose of the provisions is to supply the public with current, accurate information so that the investing public can make informed decisions. In determining and considering the appropriateness of a sanction, this Commission has often looked to the guidance, the public interest factors under Stedman versus SEC. In numerous Section 12J cases, administrative law judges have also used those factors. A fuller analysis of the 6 public interest factors is contained in the division's brief, but if I may highlight 2 for you this morning that are particularly relevant. First, Eagletech's failure to comply with the reporting requirements is not an isolated event, but continues through the present. Since its last filing in February 2002, Eagletech has failed to file 3 annual reports and 11 quarterly reports over those 4 years. As this Commission has made clear, the reporting requirements are the primary tools to protect investors by ensuring that the investing public receives current, accurate information about the operation and financial condition of an issuer. The absence of public information about the company is particularly egregious in light of Eagletech's condition at the time of its last filing more than 4 years ago. In that quarterly report filed February 19, 2002, Eagletech identified several significant impediments to its continued operation, including the need to raise additional capital. In that filing, it also stated there were substantial doubts about its ability to continue as a going concern. It stated it was delinquent in accounts payable, convertible notes payable, and salaries to personnel. It is also significant that since Eagletech's last filing, the company has not filed any current reports disclosing to investors material of events that have occurred. At the pre-hearing conference in June of last year, Mr. Young informed the law judge that Eagletech's former outside auditor, Sweeney Gates & Company, had resigned, and that because of the continued deterioration of Eagletech's financial condition, Mr. Young had relocated the offices of the company and now ran Eagletech from his home. Nonetheless, at no point had Eagletech filed a Form 8K or otherwise informed the investing public of these events. Second, Eagletech has not offered any assurances that it will comply with the reporting requirements now or in the future. The Division of Corporation Finance notified Eagletech in August of 2004 that it was first delinquent in its filings. At that time, the division staff informed Eagletech that it was at risk of having its securities revoked. The securities registration revoked. Through counsel, the company claimed that it intended to comply with the reporting provisions, but took no steps to cure its prior violations or file current reports. In that case, in this circumstance, the facts before you are distinguishable from the Commission's recent decision in eSmart Technologies. In eSmart, the Commission recognized and identified that the ability to comply and, in fact, the subsequent filing by a company was a relevant factor in determining whether deregistration was the appropriate sanction. However, in eSmart, the company had hired securities counsel specific for securities work. It had engaged an auditor and had begun to prepare filings, and in fact, at the time of the deregistration, had made subsequent filings. In this case, Eagletech has not made any steps, had not taken any affirmative steps to comply with the provisions, has not engaged an auditor, has not filed periodic reports or current reports, or prepared audited financial statements. Let me at this time respond to some of Mr. Young's allegations. With respect to the issue of taking, there's two claims before you. The first claim is that Section 12J amounts to a taking. The division suggests that that claim is meritless. First, registration of a security is not a right. It is a privilege conditioned upon compliance with the Exchange Act and its rules. In this instance, Eagletech was put on notice of its delinquency. It has been aware of its failure to file current, accurate financial information for more than 3 years. It has also been presented with an opportunity to be heard, both before an administrative law judge and, in fact, today. Now, with respect to Eagletech's second claim, Regulation SHO was enacted by the Commission in 2004.